Welcome to our fun little study group for PP 5340 Introduction to Public Policy and Management. This up in part 2 of extra segment from the readings from section '07, The Origins of Mass Incarceration and Sentencing Reform, focused on articles supported by the Sentencing Project.
Absolutely. And we're diving deep today into some really crucial material. We're pulling from Beyond Bars, so a path forward from 50 years of mass incarceration in the United States.
Right, that rapid response volume.
Exactly. It's edited by Kristen M. Budd, David C. Lane, Glenn W. Mushert, and Jason A. Smith. And it's framed as a direct response to, well, what they call the 50-year failed experiment in mass incarceration the U.S. kicked off around 1973.
Yeah, that 50-year mark really hits home. So our mission today really is to pull out the key evidence, the potential solutions from, 9 chapters in a think piece.
That's right. Covering pretty much the whole spectrum of collateral damage. We're talking housing, prison labor, voting rights, family impacts, you name it.
And Shirley A. Jackson, in The President's Welcome, kind of sets the stage, framing it as a roadmap for social justice.
And Mark Maurer's foreword drives that home, too. He stresses that mass incarceration has just caused so much harm, way more harm than any supposed public safety benefit.
So the argument is we can't just tinker around the edges.
No, exactly. Maurer says we have to challenge the core assumption that extreme punishment is the only way. We need to figure out what actually dismantling that looks like.
Okay, let's jump in. First up, the sheer scale of punishment. Ashley Nellis provides some pretty sobering analysis here.
Yeah, Nellis kicks things off with a statistic that, honestly, just stops you in your tracks. She argues that life sentences have become this, defining feature of mass incarceration.
The growth has been that dramatic.
Unbelievably so. Get this. Today, there are more people serving life sentences, and that includes life with parole, life without parole, or LWOP, and these so-called virtual life sentences.
More people than what?
More people serving life today than the entire U.S. prison population back in 1973 when this whole era started.
Wow. Okay, so we've basically replaced the entire prison system of 50 years ago just with people serving life terms now.
That's the magnitude. We're talking over 203,865 people as of 2020. And the growth in LWOP, life without any chance of parole, it shot up 66% just between 1984 and 2020.
And you mentioned virtual life sentences. What exactly are those? Are they officially called that?
No, it's a term researchers use. It refers to these mandatory maximum sentences of 50 years or more.
So if you get 50 years when you're, say, 22.
Right. You're effectively serving life. You'll likely die in prison. Nellis points out there are about 42,000 people serving those kinds of sentences right now. It functions like LWOP.
And the racial disparity here is stark, as expected.
Depressingly so. More than half of the people serving the absolute most extreme sentence, LWOP, are black.
Which leads right into Nellis's point about how certain laws contribute to this, like felony murder laws. How do those work to expand life sentences?
It's a really critical piece of the puzzle. Felony murder laws basically say if you're involved in a certain type of felony, like a robbery, and someone dies during that crime, even if it wasn't you who caused the death, maybe you weren't even there.
You can still be charged with murder.
Yes, and potentially get a life sentence, sometimes even mandatory LWOP. It's this extreme expansion of culpability, holding people responsible for actions they didn't directly commit or intend. Thousands get caught in this.
So you have these laws expanding culpability, driving up life sentences, especially for Black individuals. But how does this square with what we actually know about crime and, human behavior?
It doesn't square at all. That's Nellis's core argument, and it comes up again and again in these readings. The expansion of these super long sentences completely ignores basic criminology, especially the age crime curve.
Explain the age crime curve again, just briefly.
It's one of the most established findings in criminology. Basically, involvement in crime peaks in the late teens or early 20s and then declines sharply. Most people naturally age out of criminal behavior by their mid to late 20s.
But the sentences don't reflect that at all.
Not even close. Nellis notes about 40% of people serving LWOP committed their crime before they were 26. They were young, maybe impulsive, brains not fully developed.
And they're sentenced to die in prison long after their risk level would have naturally dropped.
Exactly. Decades after. So if the goal is deterrence or public safety, locking someone up into their 60s or 70s for something they did at 25 just doesn't make scientific sense. Their risk is minimal by then.
And the data on people released from life sentences seems to back that up, right? Very low reoffending rates.
Remarkably low. Less than 5% end up back in prison for a new offense. Criminal careers, statistically speaking, tend to last about 10 years. So the policy is just incredibly inefficient and, frankly, disconnected from reality.
So why the push for ever longer sentences? Politics.
That seems to be the driver. It's about appearing tough on crime, not necessarily smart on crime. Nellis uses Louisiana as a stark example of this historical shift.
Ah, the 106 law. Tell us about that.
Yeah, Louisiana used to have this law, informally called 106. It meant people sentenced to life were generally eligible for release after serving 10 years and 6 months, assuming good behavior. It was a built-in path to release.
But that changed.
Dramatically. After 1979, Louisiana abolished parole for life sentences and made LWOP mandatory for first and second-degree murder.
Yeah.
Just like that, the door to release slammed shut.
And the result today in Louisiana.
It's devastating, especially for the black community. 1 out of every 5 black men in Louisiana's prisons is serving a life sentence with absolutely no chance of parole, a direct result of that policy shift.
In Tennessee shows a similar pattern.
Yes, with gradual legislative changes stretching out time served, it culminated in the 2022 Truth in Sentencing Act.
What did that do?
It basically requires people sentenced to life to serve 100% of a 60-year minimum term before they can even be considered for parole, 60 years. It essentially makes parole impossible for almost everyone.
So given all this, the scale, the disparities, the disconnect from science, what solutions does Nellis propose? It sounds like incremental change isn't enough.
No, she argues for a radical downgrade in severity. She points out that LWOP is almost non-existent in other developed countries. They see it as inhumane, denying any possibility of change.
So what's the concrete proposal?
End LWOP completely and cap all prison sentences at a maximum of 20 years.
Wow, 20 years max for everything.
That's the proposal, with an initial review of the case within the first 10 years. To get there, you'd have to dismantle the whole structure, get rid of long mandatory minimums, stop stacking sentences consecutively, eliminate those enhancements that pile on extra years.
That's a huge shift. Politically, that sounds incredibly difficult, even if the public says they support rehabilitation.
Oh, absolutely. It's a massive political lift. But Nellis and others in this volume are arguing, look, if we're serious about ending mass incarceration and its harms, this is the direction we have to move. We need to align policy with evidence and, frankly, with basic human dignity. Setting that 20-year cap is the benchmark for what real change requires.
Okay, so that sets the stage on extreme time served. But punishment isn't just about time, is it? It's also about money. Let's shift to mass criminal legal debt, based on the work by Michelle Cadigan, Alexis Harris, and Tyler Smith.
Right. This is a huge piece, often overlooked. They argue that monetary sanctions, what they call legal financial obligations, or LFOs, are actually the most common form of punishment in the U.S.
LFOs, so that's fines, court fees, restitutions, surcharges, interest.
All of it. And they argue this system isn't really about accountability. It's driven by the government's need for revenue. It creates this massive burden they call mass criminal legal debt.
And this fuels a two-tiered system of justice, basically. If you can pay, you get out. If you can't, you're stuck.
Precisely. They call it layaway freedom. Your ability to actually exit the criminal legal system hinges entirely on whether you can pay off these debts. If you can't, warrants get issued, more fees pile up, maybe your probation gets violated.
And you end up back inside, potentially.
Exactly. All because you couldn't afford the fees. And this debt affects everything: finding a job, keeping housing, parenting, even just driving legally.
Their multi-state study had some specific, really concerning findings, didn't it?
It did. They found, for example, that indigenous people in Minnesota face the highest average LFO debt loads, showing how these burdens fall unevenly.
And the link between city budgets and women's incarceration in Washington state, that was striking.
Yeah, they found that cities relying more heavily on LFOs for revenue actually had higher rates of incarcerated women. It suggests that financial pressure itself might be driving more women into the system.
It's like the need for money is influencing who gets locked up.
It points in that direction.
Yeah.
And the way this debt follows people, even inside prison, is predatory. They talk about commissary funds.
Money sent by family for basic needs.
Right. Soap, toothpaste, phone calls. But the state can divert huge chunks of that money. They cite cases of up to 97% to pay off LFOs.
97%. So families are sending money just for the state to take it.
Pretty much. It punishes the family and makes it impossible for the incarcerated person to even buy necessities. It just traps everyone deeper in debt.
Okay, so if the system is driven by revenue needs and creates these traps, what are the solutions proposed by Cadigan, Harris, and Smith?
Fundamentally, they say governments have got to stop using the justice system as a revenue generator. This offender-funded model has to go.
Because trying to squeeze money from people who don't have it is just pointless.
Worse than pointless.
Yeah.
It's inefficient, it's punitive, And it doesn't even work well fiscally. They argue courts, police, all this should be funded through general taxes, not fees tacked onto the poorest people.
And the key is assessing ability to pay.
Absolutely central. Eliminate mandatory LFOs. Courts must determine a person's current ability to pay before imposing any financial sanctions. And that assessment has to be real, considering things like disability, medical debt, childcare costs.
And if someone is truly indigent,
Complete relief. No LFOs. Period. If someone's homeless or on disability, they shouldn't be burdened with court debt.
what about the link between debt and driver's licenses? That seems like a major trap.
It is. They argue strongly. Stop suspending licenses just for unpaid fines and fees. It makes it impossible for people to get to work to earn the money to pay the debt.
A total catch-22.
Right. And they go further. Driving while license suspended? If the suspension is just for debt, shouldn't even be a criminal offense. It just deepens the entanglement with the system for no good reason. Hashtag tag to be the problem of prison labor.
From financial debt to, well, literal servitude. So let's talk about prison labor. Yvonne A. Braun and Kellen Pollock Kirkpatrick connect this directly back to the Constitution, don't they?
They do, specifically to the 13th Amendment. Everyone knows it abolished slavery, but there's that crucial exception clause.
Except as a punishment for crime whereof the party shall have been duly convicted.
Exactly. That loophole, ratified right after the Civil War in 1865, was immediately used, particularly in the South, through things like black codes and convict leasing to essentially re-enslave black people through the criminal justice system.
And Braun and Pollock Kirkpatrick argue that this isn't just history. That loophole is the foundation for modern prison labor.
Absolutely. They argue it links directly to the over-policing of black communities and creates a system where labor is expected, often required.
How many incarcerated people are we talking about working?
Estimates are between 65 and 80%, and it's often not really voluntary. Refusing work can lead to serious punishment, solitary confinement, losing visits, losing good time credits that could shorten your sentence.
So coercion is built in. What kind of economic output are we talking about?
It's massive. Over $2 billion a year in goods sold on the open market, things like furniture, clothes, even military equipment, and another $9 billion in services just to maintain the prisons themselves, cooking, cleaning, maintenance.
And the pay?
Often pennies an hour, sometimes literally nothing. And even when they do earn something, states are allowed to deduct huge amounts, up to 80% for room and board, taxes, restitution, court fees.
So the state benefits hugely, the workers get virtually nothing, and what little they earn often gets clawed back.
That's the system. And safety is a major issue too. Prison workplaces often aren't covered by standard OSHA protections. Think about incarcerated firefighters in California, incredibly dangerous work for maybe $1 or $2 an hour.
And then they face barriers getting firefighting jobs on the outside because of their record.
Exactly. It's exploitation from start to finish. Plus, Braun and Pollock Kirkpatrick point out a broader economic impact.
How does it affect the wider labor market?
Well, having this huge pool of ultra-cheap, coerced labor suppresses wages for low-wage workers on the outside. Why pay market rates or deal with unions when you can get state-subsidized prison labor? It also artificially lowers unemployment stats by warehousing potential workers.
So what's the core solution they propose? It has to start with that loophole, right?
Yes. Amend the U.S. Constitution to close the 13th Amendment loophole entirely. Pass the Abolition Amendment. That's the fundamental fix.
And in the meantime, or alongside that,
treat incarcerated workers like any other workers. Pay them fairly, at least minimum wage, ideally industry standards. Provide the same safety protections, like OSHA oversight. And crucially, work must be truly voluntary.
meaning people can opt out?
Yes, without facing punishment. Anything less, they argue, is just a continuation of involuntary servitude enabled by that constitutional exception.
Okay, so we've seen the extreme sentences and the economic burdens. Now let's look at what happens when people are eventually released or try to get released. Kimberly D. Richmond looks at the problems with parole.
Right. So partly due to court orders like Brown v. Plata in California, which dealt with overcrowding, the number of parole hearings has actually gone way up. California had over 7,600 recently.
So more people getting hearings? That sounds like progress.
You'd think so, but Richmond argues the process itself is deeply flawed. Decisions still hinge heavily on these really subjective, fuzzy criteria.
Like what?
Things like whether the person shows enough insight or remorse. The problem is, psychological research shows people are actually terrible in judging these things accurately, especially in a high-pressure setting like a parole hearing.
So it becomes about the board members' gut feelings rather than objective risk.
Pretty much. Decisions can be inconsistent, biased, and it forces people seeking release into what Richmond calls a performance conundrum.
The program speak issue.
Exactly. People learn they have to talk a certain way, use the language taught in prison programs about taking full responsibility and showing deep remorse, whether they genuinely feel it that way or not. It's a performance to convince the board.
But this performance requires accepting total culpability, right?
Yeah.
Minimizing any external factors.
Yes, and that's the toxic part. They often feel pressured to downplay things like poverty, abuse, addiction, systemic racism, anything that might contextualize their actions, because the system rewards this narrative of complete personal failure and redemption through self-blame.
And this creates a vicious cycle, particularly for people who might be innocent or feel their sentence was unjust. Richmond calls it the innocent prisoner's dilemma.
It's a brutal dilemma. If you maintain your innocence or argue mitigating factors, the parole board sees you as lacking insight or remorse and denies parole. You stay locked up.
But if you do perform the remorse, admit total guilt just to get out.
That admission, made under duress, can then be used against you later. Say you have an actual innocence claim, or you're seeking resentencing under a new reform law. The DA can point to your parole hearing transcript and say, look, they admitted full culpability.
So trying to get free actually undermines your chance at justice later on.
Exactly. It's a system that traps people.
So how do we fix this? How do we make parole decisions more rational?
Richmond suggests several things. First, set clear standards. Limit how long someone waits for parole eligibility, maybe 25% of the minimum term, with an initial hearing guaranteed within 10 years.
And change the default assumption at the hearing.
Yes. Start with the presumption of release, especially for older individuals. We know their risk is incredibly low, less than 1% recidivism for those over 65. If the board wants to deny release, they need concrete, verifiable evidence of a current danger, not just rehashing the original crime from decades ago.
And protect people from their own words in that hearing.
Crucial. Pass laws that limit or outright ban the use of parole hearing transcripts in other legal proceedings, like resentencing or innocence claims. Acknowledge that what someone says under that kind of pressure isn't reliable evidence for other purposes. Hashtag 3B, housing, employment, and reentry barriers.
Okay, parole is one hurdle. But even if someone gets out, finding stable housing and a job is maybe the biggest challenge. Maria Valdivinas Olson lays out the scale of this problem.
Yeah, the link between homelessness and incarceration is stark. People coming out of prison are almost 10 times more likely to experience homelessness than the general population.
And homelessness directly increases the risk of going back to prison.
Absolutely. Without a stable place to live, everything else falls apart. Olson talks about the criminal record ceiling.
How many people are affected by that?
The estimates are huge. Somewhere between 70 million and 100 million people in the U.S. might face barriers to housing or employment simply because they have a criminal record. That's a massive chunk of the potential workforce.
And we see this play out in hiring discrimination, right? Even with policies like ban the box.
Right. Ban the box, aim to delay the question about criminal history, give people a foot in the door. But audit studies still show that people with records get far fewer callbacks.
And Olson points out an unintended consequence, particularly for Black men.
Yes, this is a really important nuance. When employers can't ask about criminal history up front, some may fall back on racial stereotypes and assume Black male applicants are riskier, screening them out earlier in the process.
So the discrimination just shifts. It doesn't disappear.
Exactly, which means we need solutions that actually change employer behavior and risk perception, not just the timing of the question.
What does Olson suggest to incentivize hiring?
Things like expanding the work opportunity tax credit for employers who hire people with records. Also, making crime and safety insurance more readily available to businesses could help alleviate fears. One study she cites showed employer willingness jumped significantly, from 39% to over 50%, just with a small incentive.
What about certificates of rehabilitation, or NEWARs?
These are official documents that certify someone has been rehabilitated. They can offer employers legal protection against negligent hiring lawsuits, a major concern for businesses. SICORs can also help with finding housing, but they work best when paired with laws that require employers to give a specific job-related reason if they reject someone with a CR.
And thinking systemically, Olson brings up the idea of time limits on how long a record can be used against someone.
Yeah, drawing a parallel to the Fair Credit Reporting Act, which limits negative credit info to about 7 years. She proposes a Fair Criminal History Reporting Act with similar time limits.
Based on the fact that recidivism risk drops significantly over time.
Exactly. After 7-10 years crime-free, A person's risk is basically the same as someone who was never arrested. The reporting should reflect that reality.
And our Neil Green and Noah Painter-Davis add another layer, focusing on preventing criminalization in the first place, especially for homelessness.
Right. They point out how cities increasingly pass laws criminalizing homelessness between 2006 and 2019, banning sleeping outside, loitering, etc. This just pushes people into the legal system for issues related to poverty and lack of housing.
So their solution involves diverting people away from the police?
Yes, using something like the cascade of care model, focusing on prevention, identification, treatment. They emphasize pairing this with linkage facilitation services, often using peer providers, people with lived experience.
So these teams connect people directly to services.
Exactly. Instead of arrest, they divert people experiencing homelessness or mental health crises directly to housing, healthcare, substance use treatment. Providing that stability up front is key to breaking the cycle.
Okay, so we've covered time, money, parole, housing, jobs. Let's turn to pathways for upward mobility that get blocked education and political participation. Alicia Asseltine focuses on higher education in prison.
And the impact is just undeniable. Asseltine highlights research showing that any educational program in prison cuts recidivism by up to 43%.
43%, that's huge.
It is. And for those who participate in actual college programs, the recidivism rate drops below 10%. These programs boost employment, earnings, and save taxpayer money on incarceration costs. It's a clear win-win.
But historically, access has been severely limited, largely due to the Pell Grant ban in 1994.
Right. That ban cut off federal financial aid for incarcerated students for almost 3 decades, creating educational deserts inside prisons. The good news, as Asseltine notes, is that Congress finally restored Pell eligibility effective fall 2023.
That's a major step. But Pell Grants returning doesn't solve everything, does it? Colleges themselves still put up barriers.
Huge barriers. Nearly 3/4 of colleges screen applicants based on criminal history, even though there's little evidence it improves campus safety. And this disproportionately affects Black applicants.
And the screening doesn't just stop at admissions, right?
No, it extends to campus housing, sometimes financial aid, even specific majors that require professional licenses later on. Plus, about 33 states still have laws blocking incarcerated students from receiving state financial aid.
So the solutions Asseltine proposes are about tearing down these barriers.
Pretty much. Repeal those state laws limiting aid. Create bridge programs to help students transition back into academics after years away. And critically, colleges need to eliminate criminal record screening for admissions, aid, housing, and campus jobs.
And tackle the stigma head on.
Definitely. Awareness campaigns are needed because faculty, administrators, even fellow students often hold negative stereotypes or fears about formerly incarcerated students. We need to address the social barriers too. #4B. Denial of voting rights.
From exclusion from education to exclusion from democracy itself, Christopher Uggan and his colleagues lay out the scale of felony disenfranchisement.
And the scale is massive. They estimate over 4.6 million American adults cannot vote because of a felony conviction. That's 2% of the entire voting eligible population.
And many of these people aren't even incarcerated anymore.
Almost half, 48%, have fully completed their sentences. They're living in the community, working, paying taxes, but they're denied a fundamental right of citizenship.
The racial disparities here are particularly egregious.
Yeah, 5.3% of voting-age African Americans are disenfranchised nationally, compared to 1.5% of non-African Americans. And some states, Alabama, Mississippi, Tennessee, it's over 14% of eligible Black voters. Just staggering numbers.
How does the U.S. compare internationally on this?
We're a major outlier. Most democracies don't disenfranchise people after they've completed their sentence. Uggan and his team traced this practice back to post-Civil War efforts to suppress the Black vote. It's rooted in racial exclusion, not public safety.
And is there any evidence that denying the vote actually improves public safety?
None whatsoever. In fact, the opposite seems true. Research consistently shows that civic participation, including voting, is linked to successful reintegration and law-abiding behavior. Restoring the vote seems to help people reconnect positively with society.
So the solutions focus on full restoration.
Yes. Priority 1. End post-sentence disenfranchisement. Those 11 states still doing it need durable legislative fixes, not just executive orders that can be easily reversed.
And what about people still on probation or parole?
Repeal those restrictions too. There are 24 states that disenfranchise people under community supervision. It makes no sense. Supervision is supposed to be about reintegration, and voting is part of being an engaged citizen.
They also mentioned jail voting.
Right. Many people held in local jails awaiting trial or serving misdemeanor sentences legally retain their right to vote, but logistical barriers often prevent them from actually casting a ballot. Jails need better procedures for registration and ballot access.
And finally, they warn about a chilling effect.
Yeah, from aggressive prosecutions for supposed illegal voting by people with felony records, even when it seems to be based on confusion about eligibility. We've seen this in Florida, Texas, Tennessee. It scares eligible voters with records away from the polls.
Okay, after dissecting all these problems, let's end on a more hopeful note, maybe. Francis T. Cullen, Justin T. Pickett, and Cheryl Lero Johnson argue that the peak era of mass incarceration might actually be over.
That's their core argument, and they have data to back it up. Between 2011 and 2021, the total number of incarcerated people in the U.S. dropped by 21.2%. That's a significant, sustained decline, from about 2.25 million down to 1.79 million.
And juvenile detention numbers are even more dramatic.
Astounding, really. A 77% drop between 2000 and 2020. And while the racial disparities are still terrible, they are narrowing. The black state prison population fell nearly 29% in that same period, reducing the black-to-white incarceration ratio from 8.2 to 1 down to 4.9 to 1.
Still awful, but moving in the right direction.
Exactly. And Cullen and his co-authors argue this isn't just numbers. There's a shift in thinking, a new sensibility.
How so?
The language is changing. We're moving away from that harsh punishment imperative. James Q. Wilson's "wicked people exist, lock them up" idea towards terms like justice-involved individuals, redemption, second chances. Public opinion polls consistently show strong support for rehabilitation over just punishment.
But there's a but, isn't there? The scale of the problem is still massive.
That's the challenge of the legacy. They cite Nazgul Ganush from the Sentencing Project, who calculated that at the current pace of decline, it would still take 57 years just to cut the U.S. prison population in half.
57 years. Wow, so incremental change isn't enough.
No, we've made progress, but the wreckage of mass incarceration is still enormous. This leads to their warning about progressophobia.
Progressophobia, what's that?
It's this sort of inability to accept good news, to acknowledge that progress is being made, and then to build on it aggressively. They argue we need to accept the era of escalating punishment is over and use this moment to fundamentally rethink what prisons are for.
Grounding reform in human dignity.
That has to be the foundation. They point to models like Norway, which operates on a principle of normality, meaning the punishment is simply the loss of liberty. The conditions inside prison should resemble life on the outside as much as possible. No added degradation, no isolation purely for punishment's sake. Focus on rehabilitation, connection, and preparation for release from day one.
And we're seeing experiments like this starting in the U.S., like San Quentin in California.
That's a huge example. California earmarked $20 million to transform San Quentin, a really old, notorious prison, into a center focused on rehabilitation and restorative justice, explicitly modeling it on the Scandinavian approach.
Moving away from giant cell blocks to smaller units, more community integration.
Exactly. Communal living spaces, job training that leads to real jobs, integrating community services into the prison. It's about creating environments designed to actually change people, not just warehouse them in beds and cages.
So the call is to stop building based on the old failed blueprints.
Yes, we know that didn't work. The opportunity now, Cullen and his colleagues argue, is to experiment boldly with new ways to create institutions that foster positive change and successful reentry. Hashtag out of track outro.
Okay, wow, let's try to pull this all together. If you step back from all the details, what really strikes me is how interconnected everything is.
Yeah.
Mass incarceration isn't just one policy, it's this whole web.
Absolutely. It starts with extreme sentences, adds crushing debt and exploitative labor, creates parole systems that trap people, blocks access to basics like housing and jobs, strips away educational opportunities and voting rights.
It's a lifetime of consequences designed almost perfectly to ensure failure, not rehabilitation.
Right. And reversing it requires tackling all these things at once. You can't just fix sentencing without fixing reentry. You can't just fix reentry without addressing the economic burdens. It needs broad, coordinated policy change.
And if we tie this back to the overarching theme from folks like Shirley Jackson, Kara Gotch, Kristen Turney, it's about redefining safety and justice, isn't it?
Exactly. True community safety isn't achieved by having the highest incarceration rate. It's achieved through effective reintegration, reduced inequality, strong social supports, measuring success by how well people do after contact with the system, not just by how long we lock them up.
Which brings us back to that idea of resisting progressophobia. If we accept that the old punitive logic failed, that the era of just getting tougher and tougher is over, it really opens up space for new thinking.
It really does. The evidence supports a different path.
So here's the final thought for you, the listener, to chew on, building on everything we've discussed. If we truly accept that the mass incarceration experiment failed and we need radical change,
Knowing that the old system needs to be dismantled, not just tweaked. What's the most radical, maybe unconventional experiment in community safety and human rehabilitation you would fund right now? Think beyond prisons. Maybe universal basic income for returning citizens. Guaranteed housing, free education, total debt relief. What bold step would you take to truly replace the old logic?